The following program is suitable for general audience of any age.
Tonight, we discuss civil appeals and its procedure in Sri Lanka. What laws govern this framework and what are the practical obstacles of the process? A very good evening and thank you for joining us on yet another episode of Law, Land and Liberty, where we bring to you key legal concepts and break it down for the layman. Today's topic is something that we have not touched on previously due to the vast scope of its nature, and that's on appeals. And to take it from a step-by-step basis, we will be starting with just civil appeals for this program. And to speak about this, we have someone that is not a new face on the program, and we're very glad to have back onto the program. Thank you for coming back, Mr. Chandima Perumpuliarachchi, attorney at law. So thank you so much for coming to the studio. Really appreciate your time here. A bit of an insight into Mr. Perumpuliarachchi. He is the co-chair of the Law Week subcommittee of Bar Association of Sri Lanka. He was also the former president of the Mathura Bar Society, so safe to say we're in very good hands when getting into the depth of this topic. How we will be approaching this topic is as such: we will be going into the fundamentals and the foundational basics, the understanding of the structure, specifically when it comes to civil appeals. Next, we'll be getting into the practical and procedural obstacles and hurdles that we can see, and finally we'll be getting into the reforms aspects and the amendments context as well. What exactly we can expect to see as developments moving forward in this area of the law in the years to come.
Hello, my name is Ranil Gonicha. I am an undergraduate of University of Derana. My question is on fundamentals. How appeals are governed in civil law context?
All right, well, without any further ado, let's get right into this discussion. Thank you very much, sir. Once again, we really appreciate your time. But before we get into any of the nuances of civil appeals in its context, I think it's important for us to get an understanding on what exactly an appeal is in the Sri Lankan legal context. How exactly does an appeal get counted in the Sri Lankan legal context, and also what are the differences between revision applications and also applications for restitutio in integrum? I think it's important for us to get the basics down first, sir.
An appeal is a remedy available to a party, only to a party to a case, and he must be a party aggrieved by that particular judgment or order, so that he can invoke the appellate jurisdiction. So then what's done is correction of errors of law and facts in a judgment already entered in the original court. So that is appeal. When comparing that with the revisionary jurisdiction of appellate courts, what is done in revision is there are, of course, any person who's aggrieved by a judgment. He need not be a party. He can be an outsider. He can invoke the revisionary jurisdiction, but it's the court. It's an extraordinary remedy where court exercises its discretion. It's a discretionary remedy in exceptional circumstances where there's a grave miscarriage of justice. Only that jurisdiction can be invoked. So then the restitutio integrum is a remedy available to again any party, but they are also, just as in a revision, it's an extraordinary remedy where the discretion of court only that is granted, where there are exceptional circumstances, where there's a grave miscarriage of justice. And also what's done in a restitutio integrum in comparison with an appeal is restoration of parties back to their original position. Like, for instance, if mostly when there's a fraud, like say one party was asked to enter into a certain contract, he was subjected to a fraud. Then, of course, they are reverted back to their original position. Maybe the money paid is reverted back. Any good purchase is reverted back to the sellers, like that. So those are the differences, really.
So could you also help us understand structurally the difference, the hierarchy that the appellate courts have specifically in Sri Lanka, where exactly appeals are heard and what exactly that hierarchy looks like specifically with the High Court, the Civil Appeals and then the Supreme Court. Can you give us a bit of a structural breakdown on that, sir?
Yeah, the original courts are is generally the district court, but then nowadays this Small Claims Court has been established by Small Claims Act, Judicature Act amendment, and also that is number 34 of 2022, and then commercial high courts are there. They are also regional courts. From there, appeals now from the district court and small claims courts, the appeals lie to Provincial High Court of Civil Appeals, established by Act number 54 of 2006, amending Act to High Courts of Provinces Special Provisions Act number 19 or 1990. So those are the generally the original courts. From there, appeal now from district courts, then family courts. But generally the family court jurisdiction now is mostly merged with the district court, and it's the district court that hears. So appeals lie to the Civil Appellate High Court or the High Court of Provinces of civil exercising civil jurisdiction. Then small claims court also, it's the same. But then those are generally the appeals, final appeals. Then the other thing is the provincial high courts vested with civil jurisdiction to hear commercial disputes either above a certain very high value. Now at the moment only the High Court of the Western Province has been granted that power by the Minister by of Gazette in respect of commercial disputes about 20 billion. So from there appeals lies directly to the Supreme Court. So you have to first seek leave to appeal, to proceed with an appeal from that original court. So that is generally the hierarchy.
Yes. Now that we have a bit of a foundational understanding of where exactly appeals can be made specifically and also what the differences is, I want to ask you, sir, practically where exactly is the option available for individuals? As you mentioned previously, it's aggrieved parties that can actually apply for appeal. Can you help us understand exactly what grounds, what legal grounds constitute of when a party can appeal a decision? What exactly does that area look like, sir?
Yeah. Now, if there are, it has to be an aggrieved party. At the very first thing is that, then there must be defects or irregularities in a judgment. Now, this article, section 5A2 of the High Courts of Provinces Special Provisions Amendment Act number 54 of 2006, the proviso says, merely because there's such defect, irregularity or error in a judgment in respect of a law or a legal position or a factual position, you can't appeal unless it causes any material prejudice to substantial rights of a party which has occasioned a failure of justice. So that unless because that also is fulfilled, only you can proceed with an appeal. Merely because there's an error in a judgment, because these are courts of justice, not academies of law. There are judgments like Victor versus Cyril de Silva 1998 1, SLR 41, and then Minual Dhammika Thero versus Galle Sarada Thero 2003 3 SLR 247. Those judgments also state that position. Those are not academies of law, courts of justice. So the early and aggrieved party who has rights are prejudiced or substantial rights are prejudiced and or some failure of justice has been occasioned, then only he can lodge an appeal.
Right. And now I think since we're moving forward towards the areas in which one is able to lodge an appeal, I want to go into a bit more of a specific related to that. The difference when it comes to appeals related on matters of law and the matters of factual correspondence. Can you help us understand when exactly each of these can be invoked in what specific situations?
Yes. Now, for instance, if on some application of a law, on application of a law, if court has made an error, straight away the appellate court can intervene in an appeal and correct that. But errors of facts, there are errors which are based on the veracity or credibility of a witness. So sometimes that kind of factual error, one might see that as a factual error, but it's the judge who sees the witness who has made that such determination of facts. So the appellate courts are generally slow to intervene in such situations, such errors of facts, but some errors like, for instance, a wrong inference on a document or something which is very obvious, definitely appellate courts will interfere. Yeah.
Right. I want to get to the specifics relating to the timelines of filing appeals as well, and also a previous look onto exactly what the specifics are when it comes to appealing and the process for appeals. Can we please move on to that area as well, sir, to exactly understand how much leave is given specifically when it comes to applying for appeal? Is there a set duration? Is there a cap? What does that look like, sir?
Yes. Now, we will discuss further discuss there are two types of appeals: leave to appeal applications and the final appeals. In respect of final appeals, you have to file a notice of appeal. That's the very first thing to file. That has to be filed within 14 days of the judgment, but Sundays and public holidays and the date of the judgment and the date of filing, those dates are excluded when counting 14 days. That is the notice of appeal, the very first document which is filed. Has to be filed in the original court, in the district court. Then comes the petition of appeal. You have to file a petition of appeal within 60 days of the judgment. 60 days of the judgment is that is for the petition of appeal, that is counted without excluding any of these public holidays, Sundays, etc. So then the leave to appeal applications, you straight away file petition and affidavit. That is filed in the appellate court itself, that is the civil appellate high court. That has to be filed within 14 days of the judge order. Generally those are orders of the order, but then again the Sundays, public holidays, the date of the order as well as the date of filing are excluded. Yeah, those are the timelines. Yes.
Yes. When it comes to timelines as well, now of course as you mentioned, there's a difference between leave to appeal and final appeal. I think we need to get to the specifics relating to the distinguishing of those as well, and also to understand the practical obstacles and of course the hurdles that parties that are applying for appeal can come across, especially in the current context. But before we get into any of those discussions, we do have to take a short commercial break. We'll be right back on Law, Land and Liberty here on Other Than a News channel. Please stay tuned.
My name is Tamoj Nirmani, a third year law student from Faculty of Law, University of Colombo. My question is on practicalities. What are the key issues faced when filing an appeal in Sri Lanka?
Welcome back to Law, Land and Liberty. We're in conversation with Mr. Chandima Perumpuliarachchi, speaking about civil appeals specifically and the process. We got down the fundamental basics, the foundational understanding. Thank you very much, sir, for the previous segment. I believe we were able to cover as much ground as possible. Now, bridging on the fact that we just left off for the break on specifically on the timelines that have been applicable for filing for appeal. If you can help us understand exactly if there are any exceptions towards the already existing timelines that you have already mentioned, if there are special circumstances that count towards the duration, lengthening, maybe shortening. Can you help us understand that, sir?
Yes. Now, as regards timelines, I must mention about this appeals to Supreme Court also from the Provincial High Courts of Civil Appeal. The Supreme Court rule number 7 of Supreme Court rules of Supreme Court rules of 1990 state that within 6 weeks, that is 42 days, you have to file the leave to appeal. You have to file a leave to appeal application to the Supreme Court if you are dissatisfied with the judgment of the Provincial High Court of Civil Appeal. Now, getting back to this question of exemptions or what any exemptions regarding timelines, I find this interpretation ordinance, section 8.1 says, where there's a limited time allowed to do a particular thing or take a proceeding or do a particular thing, and in that limited time period, the last day is a day that the court is closed. Then you can file it or take the proceedings, or that the wording is that file it on the very next day the court is open. So that exception is there, and in regard to that, of course, notice of appeals, of course, that it's directly applied. Then leave to appeal applications, that is directly applied. I mean, that particular exemption is applied. That petition of appeals also our courts allow, because side by side there are two authorities on that matter. There's one authority which says that you can't wait till the 11th hour and then file. That is also, that's a court of authority. Then again, there's the courts generally follow the authority that if the next date, if the last date of the time allowed is a date that office is closed, a court is closed, well then you can file on the next day. So I would like to add to this about this appeals notwithstanding lapse of time. Now, that is another mode of preferring an appeal where you have failed to lodge the appeal within the stipulated time. So that is covered by section 765 of the Civil Procedure Code. If you are not able to lodge the appeal within the stipulated time due to some reason beyond your control, and that is one. And the other thing, if you have a good ground of appeal, you can file petition and affidavit with notice to the opposing party, support it, and satisfy court on those two matters and proceed with the appeal. So those are generally the exceptions to those timelines. Otherwise, timelines must be strictly followed.
Strictly adhered.
Yes.
And on the previous question as well, when we mentioned, as you said, we do have to get into the specifics relating to the differences between leave to appeal and final appeals. Can you please give us some clarity on the distinguishing between these two? How exactly, what context is that in specifically, especially when considering is there differences when it comes to specific courts? What does that area look like, sir?
Yes. Now, the section 7541 of the Civil Procedure Code, that deals with final appeals. Then section 7542 of the Civil Procedure Code deals with leave to appeal. Then those sections must be read with section 184.1 and section 7545 of the Civil Procedure Code. So what generally those sections say is, against a person who's dissatisfied with the judgment, he has to file a final appeal, whereas a person who is dissatisfied with an order of a court, well, you have to file a leave to appeal application. But it's not as simple as the wording. Our courts have intervened and interpreted as to in what situations you can lodge a final appeal and in what situation you can go for a leave to appeal application. So in that regard, there are two approaches which the law recognizes. That is, one is the application approach and the other is the order approach. Now in Sri Lanka, the latest Sri Lankan position is that it's the application approach which is followed. Now when in trying to understand what is application approach, one has to see when a decision is made by a court, whichever way it's decided, whether it's in your favor, it's in my favor, it will stand finally and dispose of the matter in dispute, whether it's decided in my favor or it's in the opposing party's favor. But on the other hand, if it is decided in one party's favor, if the matter is concluded, but if it is decided in the other party's favor, if the case remains alive, well, there you have to go for a leave to appeal application. So that is the criterion in the application approach that has been followed in a 7-judge bench of the Supreme Court, Dona Padma Priyanti Senanayaka versus Chamika Jayanta. There are two cases combined together heard, Mohammad Zawahir versus Amana Takaful Company Limited. It's a 7-judge bench decision. Earlier, the Chettiar versus Chettiar, 2011, 2 SLR 70. Justice Chirani Bandaranayake's judgment. So that is the accepted position now. Whereas the earlier, if I just explain this order approach which existed earlier, then what you see is whether the matter is finally decided or not, finally disposed or not, whether the rights of parties are finally disposed of or not.
Right.
So that was the earlier position.
Yes.
So it didn't go deep like now. So that was the judgment of Sirivadana versus Silo, 1984, 1 SLR 286. But that the law is settled on this. However, there are situations where the statute stipulate whether it should be a final appeal or a leave to appeal application. For instance, Section 88(2) of the Civil Procedure Code as amended by Act Number 5 of 2022. Now there you seek to purge your default under Section 86, where a defendant failed to has defaulted in a case, or under Section 87 where the plaintiff has defaulted in a case. Then you give your reasons for your failure to for your default, and then the matter is inquired into and order is made. There you are bound to make a leave to appeal application. The Section 88(2) as amended earlier stipulates that. Whereas in the partition law also under Section 36A, where a court holds an inquiry into the question of modification of a final partition plan or confirming it as it is. So on that matter, that inquiry also, the application, the appeal must be a leave to appeal application. So sometimes statutes intervene and state as to what kind of appeal that should be made.
Yes, and also related as well, sir. Now, of course, there are certain situations that says that which type of appeal exactly what is recommended for that process. Are there any exceptions or any outstanding areas specifically relating to the classification of both of these as well? Now, you mentioned the order approach and the application approach as well. Can you walk us through any exceptions that may be arising in the law specifically when it comes to that area?
Yeah, that's what I explained really.
Yes,
Yeah.
I want to know about the other areas specifically now, order approach and application approach.
yes.
Following now, application approach has its own exceptions. Does the order approach also have any sort of special areas that there have been judgments made on, or is it simply just as mentioned?
No, I think this is the way. Now, earlier it's order approach which was applied, whether rights of parties are finally disposed of or not. Now it's the application approach.
So that
whichever way
the order
it's decided. Yeah. Now it's no longer there.
Right.
It's no longer followed. Now the application approach which is followed, where whether it's decided either way, the matter ends or the matter is kept alive if it's decided in one party's favor.
Right.
So those are the two tests. Now it's the application approach which is now followed. But whichever the approaches, those exceptions are stipulated by statutes.
Yes, as you just mentioned previously as well. That is good clarification that we probably needed definitely. Moving on, sir, when it comes to the documentation process, now we understand this is highly theoretical as well. We got the foundations down. But when it comes to the practical application, when it comes to actually applying to appeals, what are the biggest things that applicants need to consider specifically when considering submitting of the documents and other key pieces of information that the courts will require in order to process an application of appeal? If you could walk us through those fundamentals as well.
Now, I mentioned about the notice of appeal which has to be filed within 14 days. So the notice of appeal, what the requirements are mentioned in section 755(1) of the Civil Procedure Code. The name of court from which the appeal is preferred, the number of the action, the names of addresses of parties to the action, the names of appellants and respondents, the nature of relief claim. So then there must be a security also in respect of the cost of respondents in the appeal. That also has to be furnished, and then proof of service of the notice to the respondents. In respect of the leave to appeal application as well as petition of appeal in the final appeals, section 758(1) applies. There are also the name of court which the case is pending, the names of the parties to the action, the names of the appellant and the respondents, the addresses of the court of appeal, and the plain and concise statement of the grounds of objection to the judgment, decree or order appealed against such appealed against, and such statement has to be set forth in duly numbered paragraphs. So the petition of appeal in a final appeal must comply or conform to these requirements, and you need not file an affidavit with that, and you need not give notice to other parties also. It has to be filed in the original court. Whereas the petition in respect of leave to appeal application must conform to these requirements, but there must be an affidavit, and also it has to be filed in the appellate court, the civil appellate high court of the province. And the other thing, when it comes to a leave to appeal application, the original case record is not there for the judges at the point of granting leave. So you have to, for the purpose of establishing the case, for that purpose, it's true, once leave is granted, it's the continuation of the same case. But until such time, until the leave is granted, you have to annex the necessary documents for the purpose of establishing your case. So those are the documents which are required to be filed when you are lodging an appeal.
Yes, and I want to get to the practical aspects as well. Now, there are issues when an appeal is not properly lodged, and what exactly occurs in that kind of instance. And we also have to get to the future aspects as well, what we can see moving forward with developments into this specific area of the law. But unfortunately, we have come to time in this segment. So we are going in for a short commercial break here on Law, Land and Liberty on Other Than a News channel. Please stay tuned. We'll be right back with the final segment.
Hello, I'm Swairiyatha Kodla, a third-year undergraduate at the Faculty of Law, University of Colombo. My question is regarding the future. What can we expect as developments in this field moving forward?
Welcome back to Law, Land and Liberty. We're in our final segment in conversation with Mr. Chandima Perumpuliarachchi. So thank you so much for the previous two segments. We got a lot of fundamental and foundational understanding. Unfortunately, we are running out of time, so we will not be able to cover a lot of the areas that we should be able to with civil appeals. But sir, I think we breached on a very important area, leaving off on the previous segment, which is the practical action of actually filing for appeal and what documents are necessary to be annexed until there is an establishment of the context. Can we move on along those lines, sir, specifically understanding in your experience as a practitioner what you have seen when it comes to filing appeals as well, what you think are the biggest pitfalls when it comes to parties that are filing for appeal, what mistakes do you see, and what exactly do individuals need to be vigilant of when trying to apply for an appeal?
Yes, now for instance, under when you file an appeal under section 755, one says that either the appellant or the registered attorney can sign the notice of appeal. That doesn't mean that if you have a registered attorney on record, you can sign and file it. That is, if there's no registered attorney only. And also, when you have run out of time, mostly people go for a revision application, but the standards are very high in a revision application. So therefore, if it's due to some cause which was beyond control, that you couldn't file the leave to appeal, the appeal, and also you have a good ground of appeal, the best thing is to file appeal notwithstanding lapse of time, rather than going into this revision application where as I stated earlier, the standards are very high. So these are the common mistakes they make here.
Yes. Moving on, sir, a question of curiosity specifically. When filing an appeal, does it automatically suspend the decision, the judgment of a lower court? How exactly does that arise, especially when it comes to the current context and when cases are considered in practicality? What happens to the lower court's judgment once an appeal is filed?
Yes. Now, when an appeal is lodged from a final appeal in the district court, of course, the moment the appeal is lodged, the notice and the petition are filed, the district court becomes functus. The district court cannot proceed any further. But when it comes to leave to appeal application, until the leave is granted, it remains from the date of filing to the date of granting of leave. Well, there's a period. The judgment is the operation of the judgment or the order is not stayed. So then you have to go for a stay order. There's no automatic stay. But I must highlight this Act Number 1 of 2023, where this is Recovery of Possession of Premises Given on Lease Act. Now there the order, it's an order absolute which is made by the district court, that amounts to a writ. So that even if you go for an appeal, the execution is not stayed. Only if you succeed, you can gain compensation for your loss only. You can't recover back the premises you were on. You were a tenant also. Yeah. So
that is a very specific area as well, that stay orders, while applicable to most, there is an issue in that aspect. When it comes to appeal processes, of course, how exactly, when it comes to the developments of the case as well, new evidence can be brought in? How do appellate courts actually treat new evidence when it comes to the continuation of a case? Are there special provisions for that? What exactly does that look like, sir?
It's covered by authorities, case authorities. The criteria are, now there are two matters on that: new evidence in appeal and new issues in appeal. Now, new evidence appeal, court sees whether this particular piece of evidence couldn't have been adduced in the trial if the party acted with due diligence. That is one matter. And then if that was adduced, whether there would that could have had an important influence on the final result. No, it need not be decisive, but it has to have some influence on the final result, and whether it's apparent that it's credible. So if that is so only, the new evidence is permitted, then the new issues are permitted if it based mainly on pure questions of law. But you can't present a case in an appeal which is materially different from what the case which you presented in the district court, the original court. So those are the criteria.
There has to be context. Moving on, so specifically, now we spoke about this previously as well, when it comes to the decrees that have been given by previous courts for this judgment, how exactly does that affect a pending appeal specifically? Are those decisions executed, or as you mentioned, is there another remedy apart from stay orders? What does that look like, sir? Will it continue the flow of justice, or is it going to be postponed indefinitely until the appeal has been processed? What does that look like?
That's under from section 761 to section 763 of the Civil Procedure Code. There's a remedy called writ pending appeal. Pending appeal, you can move to execute writ, but then you have to make the respondent a party in the application, and then he is heard by court and sees whether a substantial loss will be caused to the respondent. In that event, the respondent establishes that a substantial loss will be caused, then of course he will have to deposit a substantial security, then the writ cannot be executed. So in that context, it can be asked for.
Yes, a very specific situation as well. Now, when it comes to the process of filing for appeal, specifically in Sri Lanka's context, practically what does that look like, sir, as a duration? Does the court's process have an expedited area for filing for appeal, or are we looking at a time frame of multiple years? In a practical sense, with your understanding and your practice as well, what does it look like right now, sir?
Now, right now, of course, with the decentralization of this the first step of appeal, that is, earlier it was all the appeals of Sri Lanka were heard by the Court of Appeal, whereas now it's the provincial high courts of civil appeals. So now it's expedited. Say in a matter of 1.5 years to maximum 2 years, an appeal can be concluded. And also leave to appeal applications. Now if the leave is not granted within about 3 months, the matter would be over. If it's granted, it will be about 1.5 hours to 2 hours, to 1.5 years to 2 years. But then Supreme Court, then from there you file leave to appeal application to the Supreme Court. So there's a heavy influx from right around the country to the Supreme Court. So now the Supreme Court also, the lordships have increased the number of benches. So with that, I think it's expedited. So in a matter of say 2-3 years, the matters could be concluded in the Supreme Court also, be able to in future.
Yes. Hopefully we can see that kind of development moving forward as well. Considering other appeals have been expedited, the Supreme Court can be following suit. Unfortunately, that is all the time we have to discuss civil appeals when it comes to this discussion. So thank you so much for taking the time to try and explain this very vast concept in as limited time as possible. We really appreciate your time, sir.
Thank you.
All right, we leave you tonight with the words of John Locke. Where there is no judge on earth, the appeal lies to gods in heaven. That's all we have for you tonight. You can always rewatch by catching us on our YouTube page, and we value your opinion. So please share your thoughts and feedback with us through email at feedback.adncenglish@derana.lk or by WhatsApp at 076 805 7933. Thank you very much for watching. Have a great night.